the entire time you have been charged with a very serious criminal offense. We're the Armed Attorneys. Today we're talking about why, even if you win your self-defense case, you have still lost. Stick around to the end on our pro tip on how to avoid losing 100% of the time. And before we get started, please show your support for the Second Amendment by hitting the like button.
And to start off the conversation, we have to return to this principle, and we've discussed this in the past, about what a legal justification is. Because I think a lot of people have the misapprehension that if I defend myself, save my life, save my family, save a loved one, that, that's it. We're all done here.
No crime committed, no problem.
Yes,
Yep.
and unfortunately, that's just not the case, because when we say justification, what we're talking about is your conduct would otherwise be a crime, but, it's okay because you had to defend yourself. You had to save your life. Somebody kicked down your door in the middle of the night. We have all these different scenarios. And so because we go back to that base general rule that what you're doing is a crime, pointing a gun at someone, generally a crime, pulling the trigger, shooting somebody, killing somebody, running someone over your car. Those are all general crimes, but sometimes it's okay when we're fighting for our life. And so because of that, people get charged with a crime.
Yeah, and because self-defense, defense of others, defense of habitation, all of these, justifications are what we call plea and abatements. You have to admit that you committed the crime in order to get the defense. So
you can't say, I didn't do it, but if I did, then it was self-defense.
Exactly. So you have to say, yes, I committed the crime of aggravated assault with a deadly weapon. I committed the crime of, manslaughter or murder. But this is why.
There's a comma, but. Yeah.
But, so it really does. And once you admit those elements, and particularly the more polarized self-defense and, the Second Amendment generally gets, the more often you are going to have, police officers, prosecutors who just say, aha, we got you. And now we're looking at, you really do have to prove that justification, not just in the courtroom. It's not a matter of showing up once and telling the judge, and the judge says, case dismissed, because judges typically don't have that power, right? That's a very common misconception. So it's showing up every single month in court with everything we're going to talk about in just a moment that comes with that, and then finally arguing your justification to a jury. This probably happens 2+ years after the incident itself, the entire time you have been charged with a very serious criminal offense.
Yeah, and so to answer that age-old question of if I defend myself, can I get arrested or sued? The answer to both those questions is yes. You can be charged with a crime, just as Emily was describing. And then we have this kind of second or double whammy where you can get sued civilly. So in Emily's example, it's the government, it's the state or the Commonwealth, or, wherever you are, trying to deprive you of your freedom or your liberty because they think what you did was wrong, essentially. Or, you're left in that position of having to persuade your peers that what you did was right. But then on the other side, we have individuals, family members, maybe it's the living relatives of the person that you ended up having to kill to save your own life, suing you for damages. And so we see a lot of costs incurred on both sides. What are some costs that you see associated with a criminal charge?
Sure. So you're going to be arrested. You're going to have to bond out of jail.
Yeah, a lot of states have bond.
That is a gigantic expense. So let's say, I think we could just average at, a very serious felony bond is about $50,000.
Yeah.
Of course, it varies county by county, state by state, charge by charge. But that's $5,000 typically, if you assume about a 10% down. $5,000 out of your pocket, number one. Number two, you're hiring an attorney for your criminal case, which, for these kind of charges, I would say...
Let's say not involving death, because I'd say the two big expenses are, the price differences. Was somebody hurt or was somebody killed?
Yeah. If not involving death, I don't know, what, 15 to 30 grand probably is what you're looking at. But then you're going to have to take off work once a month to head to court. You're going to have to just take the time to check in with your bondsman, maybe every single day.
Yep.
Check in with pretrial, right? You're going to have to go pee in a cup pretty regularly, which just requires you taking off work randomly
or
to
you
go
might
do.
lose your job even.
Yeah. And if you lose your job, you're not getting a new one while
Right.
you're charged with a felony offense. That's just not how employers work. If they run backgrounds, you are not getting a new job. And then what do you do for money over the course of this several years?
Right.
It is tough. Then imagine you go to trial and there's an additional trial fee with your your attorney because attorneys don't try cases for free. And like, what if you need an expert witness, right?
Well, and I'll throw in one more thing, because the scenario that Emily just laid out was if the person didn't die.
Right.
Now, what do you think? Is it a significant price difference if there's a dead body?
Absolutely. I mean, dead bodies will get you 6-figure attorney's fees every single time.
Yeah.
So
That's half of the equation. And now we move over to the civil system. And a lot of states have the same justification. And hopefully at the end of the day, going back to Emily's example, you did everything right. Your actions were reasonable and immediately necessary. Most states follow some sort of pattern like that. And you're acquitted, right? Do you get paid back your attorney's fees?
No.
Do you get paid for the time you had to take off work or lost wages? And so, in that scenario, even if you win the criminal charge, you've lost.
Yeah. Well, and not to mention, more and more these days, gun cases are extraordinarily high profile. So let's say that let's say you're the richest man in the world and all of those hundreds of thousands of dollars didn't really ding your pocketbook, but your face, I mean, think about Kyle Rittenhouse, right?
Yeah.
Like your face has still been plastered over at least your local media, maybe national media. Half the country thinks you're a cold-blooded murderer. I mean, what do you do? I mean, even if you're ultimately acquitted, I mean, how many of the people who hated Rittenhouse from the start still think he's a murderer and hate him even after acquittal? All of the 100% of them, no one who started the equation that guy is guilty of murder said, well, okay, the jury said no. They all had something else to say about it.
And so, we made it out of the criminal system, but now we have the second half of the equation, which is the civil system. And, just like there's justification in criminal cases, a lot of states have, laws on the books that say, if your conduct was justified, then maybe some have an immunity to getting sued. I would say an intermediate is maybe you're immune from damages. And some states say, no, we're just going to look at a comparative analysis and how much, each party was at fault. And so we have all these different calculations, but it still doesn't keep the person from having to respond, from hiring a lawyer, and unlike the criminal system where they're seeking to deprive you of your liberty, now we're looking at, big dollar signs in the civil world.
And I think it's important to remember that the civil jurisprudence world is user driven. So when someone files a lawsuit against you, there's no one sitting there at the clerk's office saying, oh, no, this lawsuit isn't valid.
Right.
It gets filed and you get served and you have to hire an attorney, and then that attorney has to tell the court system, whoa, guys, and this is just assuming the best case scenario, which is that there is a defense to the suit itself, which is more rare than anything else.
Yeah.
You still have to go move for that suit to be dismissed.
Yeah.
So it still takes time. You still got to answer the lawsuit, hire an attorney, and work that process out in the best case scenario.
Yeah. But, we've talking about best case scenario. Even then, just like Emily said, even when they say you can't be sued for this, you still have to respond. You really can still be sued for it. And so going to the criminal system, best outcome, you're out a whole bunch of money, but you're still free. The civil system, best outcome is maybe you don't have a giant damages awarded, but you still have to scrounge up all these fees for your attorneys. And there is a lot of stress involved with being sued, but then we have our worst case scenarios are, what if you are convicted and your sentence, your liberty's deprived, you're sentenced to prison? Well, you're probably not too worried about the civil consequences, but, we see people lose houses, vehicles, and, their retirements. I mean, these things can be extremely costly.
And we see that happen even if you're not acquitted. I mean, this is not a self-defense case, but, the best example of this is O.J. Simpson, right? You can be acquitted on the criminal side and still be convicted on the civil side. So, but I mean, even if you have won everything, you've still lost is the point here, because there's no getting back and making you whole for the years of time, heartache, and money you've had to output to fight these charges.
And I can hear the tip tapping. I can hear the comments saying, well, Richard and Emily are saying you can't defend yourself. And
No.
what do you have to say to that?
No, absolutely not. Judged by 12, carried by 6,
Yep,
right?
I'm sure.
Everybody's
everybody comment just by 12 rather than carried by 6.
No, absolutely. However, I think that really does bring us into our pro tip of the day, which is that, you can't lose a fight that you never get yourself into.
Yeah.
So, self-defense is defensive. Don't be out there looking for a fight. Don't prove a point when you know you've got a pistol on your hip, because even if you were ultimately in the right, it is just, we have clients who ultimately, they were acquitted. Jury found they did the right thing. They still lost everything. This is what we practice self-defense law every single day. I tell people you've got to avoid these interactions if you possibly can.
Yeah, make it a last resort is really a guiding principle. And, you know, and our people, we have probably one of the nicest and smartest audience, I'd say.
Oh, yeah.
I'm a YouTube expert and I go hang out all over the place, and y'all are really some of the most insightful and thoughtful people. And so, you know, y'all are all Obi-Wan Kenobi trying to de-escalate and cool things down.
Yeah.
I'm not worried about y'all. And so we are preaching to the choir a little bit here, but and reinforce it, because I know a lot of y'all are instructors, or, you know, reinforce that with your students. You know, de-escalate, avoid, make it a last resort. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and leave us a comment. What do you think about, you know, do you have resources available? Are you self-insured if you have to defend yourself? And until next time, I guess we're the armed attorneys.